When courts consider family provision claims under Section 59 of the Succession Act 2006 in New South Wales, a recurring issue is whether and to what extent allegations of historical sexual abuse by the deceased can be taken into account. This issue was notably addressed in Page v. Page, decided in 2016 and in subsequent appellate decisions. Key principles from Page v. Page and related cases. There is a reluctance to determine allegations posthumously. Justice Hallen in Page v. Page expressed the view that civil proceedings for family provision orders are not the appropriate forum to determine whether allegations of sexual assault against a deceased person are established. Such allegations are, really difficult to resolve fairly after the death of the alleged perpetrator, who simply cannot defend themselves, and when others may have little knowledge of the truth of the claims. Not a compensation jurisdiction. The family provision jurisdiction is not designed to provide reparations or compensation for abuse. Its purpose is to ensure provision out of the estate for the maintenance, education, or advancement in life of the applicant, not to compensate for past wrongs. So, evidence of historical abuse is, not always irrelevant. The appellate court in Page v. Page, decided in 2017 by the New South Wales Court of Appeal, clarified that these kinds of allegations might be relevant if they help explain the applicant's current financial need or perhaps a deprivation of life opportunities. For instance, if the deceased's actions caused the applicant to experience disadvantage or hardship that now leads to a need for provision, the court may take this into account when deciding whether proper provision has been made. But, just to be clear, courts are really cautious not to let family provision proceedings turn into, broad inquiries into historical misconduct. However, when there is a causal connection between the deceased's conduct and the applicant's present need, findings about abuse may actually be necessary to properly assess the application and the responsibilities the deceased owed to beneficiaries. Courts must weigh all relevant circumstances, including the applicant's needs, the size of the estate, and the competing claims of other beneficiaries. Allegations of abuse are just one factor among many, and must be critically assessed in the context of the specific facts of each case. While Section 59 of the Succession Act does not create a forum for compensating historical abuse, evidence of such abuse can be relevant if it establishes a causal link to the applicant's current needs. The court's focus remains on whether adequate provision has been made for the applicant's maintenance, education, or advancement in life, considering all relevant circumstances, including, but not limited to, past conduct of the deceased. For any assistance, please contact MJM Lawyers, your trusted New South Wales wills and estate lawyers led by our founder, Michaela Money, who became a solicitor in 1998 and has been an accredited specialist in wills and estates since 2009. Visit www.mjmlawyers.com.au to book an appointment or call +61 0280 3139. With a wealth of experience, Michaela Money and the team are here to guide you with confidence. Liability limited by a scheme approved under professional standards legislation. Disclaimer. This post contains information of a general nature only and is not intended to be used as advice in relation to a specific matter. Although every care has been taken in preparing the document, it may not be accurate or complete, particularly in the context of specific circumstances. MJM Lawyers disclaims responsibility for any errors or omissions.